Olá, bom dia. Sejam todos muito bem-vindos a mais um encontro do Fórum Permanente de Estudos Constitucionais, Administrativos e de Políticas Públicas, professor Miguel Lancelotti Baldez, da EMERJ, da nossa Escola da Magistratura do Estado do Rio de Janeiro. Para quem não me conhece, meu nome é Rodrigo Valadão, eu sou membro do Fórum, do que eu tenho muito orgulho, sou também procurador do Estado do Rio de Janeiro e doutor em Direito Público pela Albert Ludwigs Universität Freiburg, na Alemanha, na área de teoria, com enfoque em teoria do direito. Eu hoje estou aqui, tenho a honra e a alegria de presidir esse evento a pedido, em nome da desembargadora Cristina Gaulia, minha dileta amiga e presidente da EMERJ, que infelizmente por questões pessoais teve que se ausentar, mas que me pediu que agradecesse a todos os componentes da mesa pela presença e todos aqueles que nos assistem pelo YouTube pela audiência. Bom, esse evento aqui, diante da pauta inclusiva da EMERJ, está sendo transmitida com tradução em Libras. E os participantes desse evento, eu vou aqui nominá-los para vocês. A nossa estrela do dia, né, nosso convidado principal, é o professor Paul Craig. Para quem não conhece o professor, ele é professor de Direito Inglês na Universidade de Oxford, tem diversas publicações sobre direito administrativo e também sobre a temática da relação entre o direito inglês e o direito da União Europeia. Ele vai falar aqui para a gente um pouco dessa relação entre a Constituição do Reino Unido e a sua relação com a União Europeia. Participam também da mesa, compõem a mesa o Dr. Luiz Cláudio Martins de Araujo, membro da Advocacia Geral da União, pós-doutor pela Universidade de Oxford e pela UFRJ, e, para nossa alegria, ele é o coordenador científico desse evento. Dr. Luiz Cláudio, muito obrigado. E para debater aqui com o professor Paul Craig, nós vamos ter a honra de receber também o professor doutor Rodrigo Brandão, que ele é procurador do município do Rio, doutor em Direito Público pela UERJ. Sem mais delongas, eu passo direto a palavra ao doutor Luiz Cláudio e, na sequência, para o professor Paul Craig, para que ele possa fazer a sua exposição. Um bom dia a todos. Agradeço desde já pela audiência. Doutor Luiz Cláudio, por favor, você tem a palavra.
Obrigado, Sr. Rodrigo. Vou falar primeiro em português. I'll talk first in Portuguese, professor, and after in English, okay? Sr. Rodrigo, obrigado pela introdução. Eu sou o Rodrigo Brandão, né? Temos dois Rodrigos aqui hoje. Também é um prazer tê-lo aqui compondo essa mesa, um grande amigo, grandes amigos, né, compondo esse evento, muito interessante. Vai falar um pouquinho sobre a questão do direito inglês e como é que está essa relação do direito inglês após o Brexit com a União Europeia. Acho que é um tema bem atual, a gente vem observando diversas questões bastante relevantes nesse pós-Brexit, na relação do Reino Unido e da União Europeia, e o professor Paul vai nos ilustrar com essa questão aqui no evento. Professor, it's a great pleasure to have you here. Thanks for accepting our invitation for this lecture in EMERJ. Your talk is quite interesting in regard of this relationship between European Union and the UK, especially after Brexit. So let me introduce you for our audience, and after you can start the lecture. Well, Professor Paul Craig is a well-known person in the academic world. He's a British legal scholar, specializing in administrative European Union law. He's professor at the University of Oxford, and now he's emeritus professor at Oxford as well. I have the pleasure to be professor in 2017, studying a little bit about European Union law, and he's an excellent person, very quiet and very available for talk about different topics and different questions. Professor, thank you again for being here. It's open for your lecture. Thank you again.
Thank you very much for the kind introduction. I hope everyone can hear me, and I'm very pleased to be here, or at least with you remotely via Zoom. It's something that we've all become accustomed to in a pandemic and post-pandemic world, but at least it allows us at least one benefit is that it allows us to make contact in this way, in a way which we probably had not done or never had done before, because people hadn't needed to communicate in this way. So it's a great pleasure to give the lecture this evening, or this afternoon, this morning for you. And I'm going to share a screen because I've got some pretty detailed PowerPoints, which I'm going to share with you. So let me just see if I can get this into. Okay, so I've been asked to talk about Brexit and the UK Constitution and relations with the EU post-Brexit. This is a big topic, so I've decided to structure it into 6 parts. The first part's going to be about the UK-EU perspective, and it's going to be talking about the nature of the relationship between the EU and the UK in a post-Brexit world. And that's going to involve the withdrawal agreement, the trade cooperation agreement, and the relationship that they embody with the EU. And then the second part's going to be called the UK legal perspective, the impact on the legal order of the UK of Brexit, and I'll explain what that means. And then I'm going to have 4 more particular constitutional perspectives. These are all constitutional perspectives about the consequences of the UK leaving the EU. So number 3 is sovereignty and control. Number 4 is over and under constitutionalization. 5 is institutions and accountability. 6 is Parliament and the courts. So there's a lot of material to get through. I'm assuming everyone can see the slides. It's okay? Yeah, good. So the UK decided to leave the EU, as you probably know, after the referendum in 2016, and negotiations then began between the UK and the EU pursuant to Article 50 of the Treaty of European Union, which specifies the conditions on which a state leaves the EU. Now, it's important, for the sake of analytical clarity, to recognize or to distinguish 2 different senses of no deal. One sense is that there might have been no withdrawal agreement concluded between the UK and the EU at all. The conclusion of the withdrawal agreement was not easy, and indeed it cost Theresa May, the then Prime Minister, her position as PM. The withdrawal agreement was finally concluded under Boris Johnson and dealt with 4 principal issues: money, borders, people, and transitional arrangements. So that's one sense of no deal. There might have been no withdrawal agreement. A second sense of no deal is there might have been no trade agreement between the UK and the EU. The withdrawal agreement didn't actually touch the future trade relationships between the UK and the EU at all. If there had been no trade deal, then the UK and the EU would have traded on WTO terms, on World Trade Organization terms. The TCA, the Trade and Cooperation Agreement between the EU and the UK, was finally concluded, but it was concluded very much at the 11th hour, because basically we left in January. The withdrawal agreement was concluded in 2020, January, and there was then an implementation period of a year. So there was basically a year during which to conclude a trade agreement. And if you didn't conclude a trade agreement in that time, the implementation period ran out, and then we would be trading on WTO terms. And once again, the deal went down to the wire, very much went down to the wire, and it was only agreed in December of 2020. So that's the kind of overall architecture. Now we need to learn a little bit more about these two agreements which frame the UK and EU relationships in a post-Brexit world. So they're defined, those relations are defined by the withdrawal agreement and the trade and cooperation agreement, both of which are international agreements, international treaties. As I said, the withdrawal agreement deals with the basic terms of exit: persons, borders, money, and financial issues, as well as transitional issues. And then the trade and cooperation agreement deals with a full, constitutes a full free trade agreement in a thick sense, which was concluded in December. Now, again, pretty important to understand some of the politics as well as the law here. The UK very much wanted discussion of the withdrawal agreement and future trade relations to proceed in parallel, so that both could be completed in 2 years, and to thereby minimize the danger of a no-deal Brexit in the sense of no trade deal. This became known as parallelism. So the UK wanted parallelism in the discussions, and the EU flatly rejected it. They flatly rejected parallelism. They said the withdrawal agreement had to be completed first before any discussion could begin on future trade relations. And it insisted that the withdrawal agreement would be relatively narrowly confined to those 4 issues: people, money, borders, and transitional issues. Now, it's important again to understand the legal and political dynamics here. The dichotomy, the distinction between the withdrawal agreement on the one hand and the trade and cooperation agreement on the other was in fact built into the exit provisions as specified in Article 50 of the Treaty of European Union. What Article 50 is the basic tableau, the provision which provides for exit. It was introduced in the Lisbon Treaty, though no one at that time thought it would be triggered. But in any event, it provides the blueprint for exit. And basically what it says, or the relevant point for present purposes, is that it says that the withdrawal agreement has to be completed within 2 years of a state saying that it wished to leave the EU. So if there was no withdrawal agreement within 2 years, then the state left with no deal. So harking back to the earlier slide, that was no deal in the first sense of the term. You wouldn't have a withdrawal agreement at all. So the Article 50 says 2 years is the deadline unless all the member states agree to give an extension. And then what Article 50 says is that at some stage thereafter, what is known as future trade relations, trade agreement, could be concluded in the future. Now, that distinction between the withdrawal agreement and the free trade agreement was both rational and problematic, legally and politically, both rational and problematic. It was rational in the following sense. It was rational in the sense that a free trade agreement, the reason why you had the dichotomy between the withdrawal agreement and the free trade agreement is that free trade agreements quite often take a long time to conclude. They take a long time to negotiate and a long time to conclude. And the idea was, if a state wanted to leave, you couldn't shackle the state. You couldn't keep the state in the EU for 4 to 5 years while you negotiated a full trade agreement. Equally, that would be impossible from the perspective of the EU as well. It'd be impossible from the perspective of the EU, because you'd have this state which was half in the EU and half out for 4 to 5 years, and that would mess up stuff. So it was rational in that sense to make the distinction, but it was also deeply problematic. And it was deeply problematic for a very simple but foundational and fundamental reason, which was that it meant that Brexit was partially blind. Okay, it was partially blind. And what I mean by that is that MPs during debates which were taking place during the withdrawal agreement, discussion of the withdrawal agreement, kept making all sorts of assumptions one way or the other about whether we're going to have a soft Brexit, a hard Brexit, what the trade relationships might be, what the impact of the economy on the economy might be. Now, this was all taking place before, all those debates were happening before the UK actually, the UK Parliament voted on the withdrawal agreement. But the withdrawal agreement said nothing about those issues at all. So the bottom line was that at the time when MPs voted as to whether we should leave, they were voting blind in the sense that they had no idea whether the future trade relationships would be very soft at one end of the spectrum, or the other end of the spectrum, a very hard Brexit with almost no trade relationship between the UK and the EU at all. So in that sense, in terms of the politics of Brexit, and in terms of voting in Parliament was pretty much blind in that respect. Okay, so as I said, the withdrawal agreement dealt with a discrete set of issues. And just to repeat, it meant persons. So persons meant the rights of UK citizens in the EU and the rights of EU citizens in the UK. That's one issue. Number two was money. How much did we owe the EU when we left? And, you know, these were pretty heavy sums, and, you know, we were talking 35, 40 billion. I can't remember whether it was pounds or euros. There wasn't that much difference between them, but it was a big sum of money. And then borders primarily meant the Northern Ireland problem. And that I could easily spend a whole hour talking to you about the Northern Ireland problem, and the Northern Ireland problem is a real problem, but suffice it to say the following. The reason it's a problem is that Northern Ireland sits in the Republic of Ireland, or sits within the broader Republic of Ireland, and that meant that the boundary between Northern Ireland and ERA, the Republic of Ireland, was an external border for the EU. Now, normally when you have borders, that's not a problem. You have a border and you have border posts and border guards and border checks and everything else. But that was felt not to be possible or plausible in the context of the of Northern Ireland, because the peace in Northern Ireland, between Northern Ireland and the remainder of Ireland, was fragile. And everyone agreed that if you had a hard border between Northern Ireland and Ireland, then you'd end up with the dangers of violence breaking out again. So basically, then you had to accept there's going to be a soft border or no border between the Republic of Ireland and Northern Ireland, but that then produced a host of second-order problems. And the host of second-order problems were about, well, if how do we ensure that goods don't enter the EU by the back door through coming to Northern Ireland and then going over an open border between Northern Ireland and Éire and then coming into the EU in that way? So there was lots and lots and lots of discussion about the Northern Ireland problem. And if there is time or anyone is inclined to know more about it in the chat or question and answer session, I'm very happy to elaborate on that. And then the fourth issue was transitional issues. And there were a host of really complicated transitional issues, ongoing cases, ongoing administration, ongoing finances, ongoing programs. So even though the withdrawal agreement only dealt with those four issues, this was not, as it were, a book at bedtime. This was an international treaty which spanned 500 or more pages. So that was the withdrawal agreement. The trade and cooperation agreement dwarfs the withdrawal agreement. It too was agreed at the 11th hour, just before the end of the transitional period. It's a massive 2,500 pages, and it can be found in the official journal. And it sets the framework for future UK-EU relations. Now, again, a little bit of background here, that the negotiating position of Theresa May and of Boris Johnson with in relation to what became the TCA was very different. So for Theresa May rejected a soft Brexit. So Theresa May's position is we would not join an EU customs union, we would not stay in it, and we would not stay in or join the single market. So she was opposed to what's known as a soft Brexit. A soft Brexit is you're outside the EU, but like countries in the European Economic Area, such as Norway, you nonetheless buy into the single market and perhaps the customs union as well. The problem with the soft Brexit is it gives you the access to the single market, but it gives you no voice at the table. It gives you no voice in the rules which are going to govern you. But it does give you access to the single market. She was against soft Brexit, and she was against joining the customs union, but she was in favor of what became known as the buzzword at the time, frictionless trade with the EU. And what that meant was that the UK would consciously strive for and seek regulatory alignment with the EU so as to ensure the smooth flow of goods and services between the UK and the EU. So no soft Brexit, but frictionless trade and close regulatory alignment. Boris Johnson takes over after Theresa May is ousted or falls on her sword or is pushed off the gangplank, whichever metaphor you want. And his position was significantly different. He agreed that the UK would not stay in the EU customs union or the single market. But he was much more strongly in favor of the UK retaining regulatory autonomy post-Brexit. So any envisaged agreement would be negotiated between sovereign equals, and the government would not, quote, negotiate any arrangement in which the UK does not have control over its own laws and its political life. So he was against agreeing to any obligations by which our laws would be aligned to the EU's, or for the EU institutions, including the Court of Justice, to have any role in the UK. There are, of course, always, it takes two to tango, and there are, of course, there's always another negotiating partner. And the EU's negotiating position was very clear, as attested to by the political declaration. And the political declaration was attached to a withdrawal agreement and preceded the negotiation, the detailed negotiation of the Trade and Cooperation Agreement. Bottom line for the EU was rational entirely from their perspective. The greater the degree of regulatory autonomy sought by the UK, and the less that the UK was willing to commit to what became known as a level playing field, then the less would be the UK's access to the single market. And I'll be saying more about the level playing field in a moment, but the level playing field applies to matters such as subsidies or state aids, environmental policies, social and labor policy, and all the attendant costs, because basically, again, entirely rational from the EU side, the EU was concerned that the UK would leave the EU and then seek a competitive advantage compared to firms in the EU, and it would seek a competitive advantage in relation to firms in the EU because they would reduce their environmental standards, or they would give subsidies to UK firms, or they would water down or amend or repeal labour laws with consequences of lowering costs for UK employers. So we ended up with the Trade and Cooperation Agreement, which is now binding as an international treaty, and has been approved both by the domestic legal order in the UK and by the, as it were, domestic legal order within the EU, has 7 main parts. Part 1 dealing with common institutional provisions. Part 2 is the real core of the free trade part. It deals with trade, transport, fisheries, and other arrangements. Part 3 shows that the Trade and Cooperation Agreement goes beyond pure trade matters. It deals with law enforcement and judicial cooperation in criminal matters. Part 4, thematic cooperation. Part 5, participation in union programs and finance. 6, dispute settlement. Part 7, final provisions. Each part is divided into multiple titles, and they're also further subdivided into chapters, and that's all followed by an eye-watering, well, it's not 800 pages, it's more. Sorry, that's in a different version, by 1,200 pages of annexes and protocols. So I can't possibly, within the time available, take you through all of this, and I don't think you'd necessarily want to. But the core, the trade core of the TCA is in part 2, which deals with trade, transport, fisheries, etc. And it contains the central provisions concerning matters such as trading goods, services, public procurement, regulatory cooperation, and a level playing field. Now, very important just to grasp for the purposes of this lecture, that although this is a massively long 2,500 page deal, actually it's heavily weighted towards trading goods, and there's very little about services, which is pretty significant because the UK economy is about 75% a service economy. So where we earn lots of our money in terms of banking, financial transactions, securities transactions and the like, the City of London and all that, that's hardly touched. It is touched, there are provisions about services, but that's very much light, L-I-T-E, compared to the provisions about goods. So although it's a free trade agreement, the dimension of services received relatively little attention. And that was partly because the EU knew the importance of services to the UK economy and did not particularly want to make life easy for the UK service economy or for the UK. So it played quite hardball on the services dimension. So administrative lawyers and even EU lawyers are not necessarily consonant or conversant with international trade law, and therefore understanding an agreement like the TCA involves a steep learning curve. And again, I can't possibly deal with all that in the time I have available. But what I do want to convey in the time I have available, and I'm very happy to answer questions about this in more detail if people so wish, is just to emphasize the unbelievable complexity of these provisions, okay? Even if you're a lawyer and even, a reasonably decent lawyer with quite a lot of experience of reading detailed text, this stuff is mind-bogglingly complicated, okay? 3 brief examples of the complexity, 3 brief examples of the complexity, and that's all I have time for. So example 1, goods. Okay, so it's a free trade agreement, great. The TCA provides there are no tariffs or duties on the flow of goods between the UK and the EU, provided that the goods comply with the requirements concerning rules of origin. So the basic idea here is simple. Goods come within the beneficial regime of no tariffs or duties only if they originate in the UK or the EU, since otherwise tariff rules applicable to third countries could be circumvented by producers in those third countries routing their goods to the UK via the EU and vice versa. Yeah. So basic idea is simple. It's more detailed specification. So the more detailed specification of rules of origin is highly complex and dense. Chapter 2 of Title 1 is devoted to rules of origin. it has 31 very dense articles which specify in great detail what it means to say that a particular product originates in the UK or the EU. There are then, on top of that, a further 6 annexes which specify in even greater detail the meaning of rules of origin in relation to particular kinds of goods. Example 2, services. As I said, the UK is about 70 to 80% of service economy, and the TCA provisions on services are very thin. The TCA does contain some basic WTO provisions concerning market access, national treatment, and the most favored nation clause, an MFN clause. So in a sense, what you're getting with the TCA on services is just a default package of WTO provisions built into the UK-EU relationship. But those provisions are subject to many exceptions, and the many exceptions are dealt with in annexes, and the annexes deal with reservations, and they occupy over 240 dense pages, which set out sector-specific reservations dealing with different kinds of services. And financial services are dealt with separately yet again, and that's pretty important for the UK, because in the UK, 7 to 8% of our GDP comes from financial services, and financial services are covered even less than other kinds of services, such as legal services or architectural services. Third example, level playing field. So again, trying to get this across in a very short space of time. I mentioned already that the EU was very concerned to ensure a level playing field, that its firms were not undercut by the UK in a post-Brexit world giving subsidies to UK firms or reducing labor costs or environmental costs, and thereby giving an unfair competitive advantage to those UK firms. So there's a whole section of the TCA which deals with the level playing field, and it has different regulations or different rules relating to competition policy, state aid, state-owned enterprises, labor and social standards, etc. And each of those areas is rendered more complicated because there are procedural, substantive, and remedial obligations attaching to each part of the level playing field. Now, I'm sorry I'm going quite fast, but I realize I've got quite a lot to get through. So we need to move on to part 2, which is the impact on the UK legal order. Now, what do I mean by this? I'm going to, parts 3, 4, 5, and 6 are about the constitutional order, but I'm distinguishing that from the impact on the UK legal order, because you need to understand a little bit about this to understand the impact of Brexit in a post-Brexit world. So this is the bottom line. The European Union Withdrawal Act of 2018 converted the entire EU acquis, the entire corpus of EU law, and brought it in to UK law, into UK law. Now that might well seem strange. You might think that's really rather daft or counterintuitive. Why would you do that? Because the UK is leaving the EU, so why are we suddenly bringing the entire body of EU law into UK law? And the answer is as follows, set out on the slide. The UK had been a member of the EU since 72. A very great many areas of life were regulated and had been regulated by EU law. Now, it would have been possible in theory to consign all that material to the legal dustbin, as it were, in the event of Brexit. But that would have led to chaos. Why? Because there would have been regulatory black holes. For example, the existing EU rules relating to matters, regulated matters, concerning really important issues such as product safety or creditworthiness of banks or securities markets or intellectual property, environmental matters, consumer protection. In all of those areas and many others, the rules were EU rules. If you pushed all that stuff over the edge of the legal cliff, then you would have had a void. There wasn't any, as it were, UK law to fill the vacuum, because we've been in the EU for 50 years. You don't maintain a parallel universe of UK rules when you've got a set of rules from the EU. So there could not simply be a legal void in these areas because pre-existing EU law would not often exist. So that's the rationale for the 2018 EU Withdrawal Act. Foundational premise is that the entirety, and I'm underlying this, I'm emphasizing it, the entirety of EU law, with some very limited exceptions, is converted into UK law. And then what happens is in two stages. Stage one is that at the time of Brexit, we make sure that these EU rules, which have been retained as domestic law, are fit for legal purpose when we leave the EU, okay? And what I mean by that is that you've brought all this stuff into UK law, you're leaving, you've got to make sure it's fit for purpose, meaning the following. There might be EU rules which you brought in concerning the environment, and they impose environmental obligations, and they produce a reporting line requiring agencies or ministers to report to the Commission about the fulfillment of these environmental obligations. Clearly, that would make no sense in a post-Brexit world. So the idea was then that you would amend this legislation, these EU rules, to iron out problems of that kind prior to Brexit becoming a reality. So prior to January of 2020, there were hundreds of pieces of UK secondary legislation, usually, what we call delegated legislation, enacted in order to smooth out these problems. Then stage two is that after Brexit, at more leisure, the UK then decides whether it wishes to retain the rules, amend them, or repeal them, okay? But without any timeline hanging over its head. Now, again, the recognition that EU law should be retained has generated a whole series of complex legal issues which keep people like me in business. I could look, if I wanted to, I could write on nothing but Brexit and its constitutional implications and all that, or its legal implications. And I've written a lot on it, but there's a lot of issues. So why, just to give you a flavor of the complex legal issues for the UK legal order, forget about grand constitutional issues. We're talking about nuts and bolts, really important issues on the ground, as it were. So firstly, the way in which different types of EU law should be retained within UK law varied within the legislation. People who know about EU law will know that EU law, there are different kinds of EU law. So directives, for example, have to be implemented into national law, normally by national statute, normally by primary legislation. Regulations, on the other hand, are directly applicable within the legal orders of the member states. So the EUWA had to have different modalities for bringing all this stuff into, or retaining this material in UK law, and it differentiated between directives, directly applicable regulations and decisions, and directly effective provisions. So treaty articles which gave rise to rights, that was all brought into UK as well, law as well. The second issue that we had to deal with, the status of EU law within the UK legal order. Okay, you bring all this stuff in, but what's the status of it within your own legal order? Is it akin to a primary statute? Is it akin to secondary legislation? Is it sui generis? That's a whole nother can of worms, as it were. Then the third issue is its place relative to pre and post Brexit case law. So you've got case law both of the UK courts and of the European courts, which bears on this material that we brought in, okay? Then the salient issue is, if, for example, you brought in an EU regulation concerning the environment, and then there's, in the post-Brexit world, there's a judgment of the CJEU on exactly that regulation, what effect, if any, does that have within the UK legal order? And then a fourth issue is the way in which those principles apply within the devolved areas of the UK. We have devolution settlements which relate to Scotland and Wales and Northern Ireland. The nature of the devolution varies in the three different instances. And each of these statutes, like the EU Withdrawal Act of 2018, has one set of provisions for bringing all this material into, if you like, England and Wales. And then we have a parallel universe about bringing all this stuff in and the way in which it affects, on the one hand, Scotland, and on the other hand, Northern Ireland. And also Wales as well. And so it's really England and then the three devolved areas. Okay, time is moving on and I need to move on as well. So let me now come to the constitutional dimensions. And I have, for ease of explication and because it's important for the sake of analytical and normative clarity, divided the constitutional perspective up into a number of different areas. The first one, and perhaps the most important, is sovereignty and control. So the issue here is as follows. The considerations that informed Brexit, that drove Brexit, were eclectic, including the desire to control borders and discontent with the workings of the EU. It was, however, sovereignty that became the principal consideration that informed the UK's negotiating discourse on the Trade and Cooperation Agreement. The assumption, explicit and implicit, was that Brexit meant an accretion of sovereign power compared to the status quo ante. The thinking was cast very much in zero-sum terms. The EU had power over certain areas. These areas would be repatriated to the UK, and the UK would then take back control over its own destiny. And the assumption was that what was repatriated to the UK, that power would accrue to the UK Parliament. Okay, so the idea is Parliament's sovereignty would be increased and enhanced. Democracy would then be enhanced because our elected representatives would then have control over these issues which had hitherto been controlled by the EU. The reality has proven rather different, and there are 7 reasons which I can briefly go through to question that picture. Firstly, Parliament exercised very little by way of sovereign choice over either the withdrawal agreement or the trade and cooperation agreement. It did so in formal terms. In other words, we are a dualist country in relation as concerns the relationship between international treaties and domestic law. So an international treaty has no effect in the domestic legal order unless and until it is incorporated into that legal order. And Parliament duly exercised its sovereign authority in that respect when it enacted the European Union Future Relations Act of 2020, which gave formal parliamentary authorization to the TCA. But in reality, it exercised no control over it at all because there were severe exigencies of time. The TCA was only agreed at the 11th hour, and that meant that MPs had only a couple of days to digest a massive and dense legal text. Suffice it to say that most MPs did not read it, and even if they had a glance at it, they would not have understood it. And that means no disrespect to our MPs, because of the point I made earlier, even trained lawyers would have a difficult time understanding the TCA, let alone people who are not lawyers. So, firstly, Parliament didn't exercise much control over the TCA. Secondly, less obviously, Parliament also exercises little power over the subject matter dealt with by the TCA. So the issues which were previously regulated by the EU will henceforth be regulated through a series of bilateral treaties, such as the TCA. So, the UK has been busy going around. The International Trade Secretary, who was Liz Truss, who's now become the Foreign Secretary, was busy going around the world negotiating or seeking to negotiate a whole series of bilateral agreements. But the bottom line is Parliament has scant, if any, involvement in these decisions. The executive negotiates the treaties, The executive decides on the detail, and Parliament simply just sort of signs off at the bottom line. And that's also further driven home by the fact that within each of these trade agreements, you have a decision-making structure of its own, okay? And that decision-making structure is itself dense and complex. So, for example, within the TCA, the top of the decision-making hierarchy is a body called the Partnership Council, and there are then a whole plethora, a whole range of trade and specialized committees established by the TCA. These committees have powers to make binding decisions and recommendations, as well as delegating functions to other parties and establishing new committees. Those decisions are not made by Parliament, they're barely even seen by Parliament, they are made by ministers and those who have technocratic expertise. There's little parliamentary involvement in any of this. Thirdly, the Brexit political rhetoric is that, as I've said, Parliament would take back control. But the reality is that Brexit has led to a considerable accretion of power to the executive rather than the Parliament. The body that has gained significantly in power has been the executive, the government. An example of this, just one example of this, is that the complex Brexit legislation that I mentioned a moment ago, the EU Withdrawal Act of 2018, contains a very great number of provisions where far-reaching power is accorded to ministers to enact secondary legislation, what we call delegated legislation, with very little by way of parliamentary oversight. That power, that accretion of power, is further extended by what is known in the jargon of the trade, constitutional jargon of the trade in the UK, as Henry VIII clauses, because they're said to date back to Henry VIII. Question mark whether they do, but the bottom line is that these are clauses in primary statutes which give power to ministers to enact, to draft and enact secondary legislation, which secondary legislation can amend or repeal other primary statutes. Think about it. You're giving a power to the executive, and often a very broad power to the executive, which then enables the executive to draft and push through Parliament a piece of secondary legislation which might amend or repeal primary legislation. Sorry, just I've obviously forgotten number, miscalculated. In any event, a fifth dimension of this idea of sovereignty and control is different yet again. The assumption was, and this was very much an assumption in the anti-EU Brexit camp, the assumption was that we were constrained in terms of sovereignty by our membership of the EU. That was the whole constitutional premise or predicate, that we were constrained in terms of our freedom of action. Now, in some, as it were, reductionist sense, that's true. it's true that the EU constrained choice of the UK and all the other 27 member states. But if you think about it, that's a really rather reductionist argument, because that's the consequence of all forms of collective action. Individuals and states make choices. They can remain on their own and maximize their autonomy. They can join clubs, treaties, and the like, which perforce limit their sovereign choice in various respects, the trade-off being the benefits of membership. Now, the sixth point follows from the fifth. The idea that the UK was unduly put upon or constrained when it was a member of the EU is great if you were arguing in political terms for Brexit, but it bore scant, if any, relationship to reality. So it was a terrific slogan, which the Brexit camp used to good effect. It just bore almost no relation to reality. Why? For the reasons given on this slide. The UK, over its tenure as a member of the EU, played a very active part in shaping the very nature of the EU as it developed over time. It was a key architect of single market initiatives. It was a key architect of initiatives concerning financial services and AFSJ, the area of freedom, security, and justice. Secondly, the UK actually disagreed with very little EU legislation. It didn't exercise veto powers very often, particularly when you view the quantity of legislation over time. The UK, thirdly, notwithstanding, I mean, there's this terrible thing in the UK about, everyone's, against the European Court of Justice. Again, this is based upon just absurd empirical data. The reality is the UK generally benefited from judgments of the Court of Justice. As anyone would know who has worked in this field or who understands international relations theory or theory more generally, part of the reason you have a court is in order to ensure that people keep their word. So you have a court there in order to ensure that states, when they make a deal, stick to the deal that is made, and that there is an impartial arbiter to make sure that that happens. The UK generally benefited very greatly from the judgments of the Court of Justice when the Court of Justice was ensuring that other member states stuck to their word and abided by the by the principles and rules in the treaties. And then also the UK did very well out of what's known as differentiated integration. So if the UK didn't like a bit of EU law, it did very well in securing opt-outs or special treatment. So we opted out of the euro, in effect. We opted out of Schengen. We opted out of many of the provisions concerning the AFSJ and just picked and chose those we wished to abide by. So, this idea that when we were in the EU, we had this tremendous burden is wrong. Finally, final point about from a constitutional perspective about sovereignty and control is the flip side of this coin of the point that I've just made is that those who were arguing for Brexit very much held up a contrast, which was a completely false contrast, between sovereign control or control over our sovereignty when we were in the EU and sovereign freedom if and when we left the EU. The idea, and actually that very idea was indirectly, albeit unintentionally, enhanced by the language of, in inverted commas, free trade agreements. Free trade agreements, to the unknowing, connoted the idea of freedom as opposed to control. But as this quote on this slide from two prominent trade scholars points out, from Helga Hestermeyer and Federico Ortino, this picture of a free trade agreement as being about freedom, as opposed to the EU, which is about control, is just intellectually and normatively nonsense, or it's nonsense in terms of positive law, and it's nonsense normatively. Any trade agreement contains a whole series of provisions, the intent and effect of which is to tie and bind the respective parties to obligations contained in the agreements. And those obligations range across a whole series of issues, not just trade issues, but as we've seen in the context of the TCA, they also range over environmental policy, labor policy, and matters of that kind. I'm sorry, this is where I had a double seventh. So the legal reality is that actually our sovereign choice is constrained in very significant ways by the TCA, and Parliament's choice is constrained. We have multiple trade provisions. We have provisions about the level playing field. We have requirements in the TCA concerning what are known as essential provisions. We have obligations to use international standards. We have a whole series of things in a post-Brexit world which limit parliamentary choice. Okay, my time is running out. So briefly, point 4, and I've only got a few more slides, so we'll get through this in a few more minutes. Fourthly, a different perspective on constitutional perspective is over and under constitutionalization. So the key inquiry here is, would the perceived difficulties or shortcomings in Brexit negotiations have been different if we'd had a written constitution? There is no definitive answer, since the answer would depend on the content of a written constitution, if one were to exist, and whether the terms thereof would have alleviated the problems attendant on the Brexit process. But it might have done, okay? And in all likelihood, it would have done. So, for example, it might have contained greater protections for the devolved areas. The devolved areas, Scotland, Wales, Northern Ireland, had almost no say in any of this. There was much political rhetoric from the UK, from Westminster, saying, yes, we're in full and frank discussion with the devolved regions. The reality was they weren't. The reality was things were decided in England and at Westminster, and the devolved areas were presented with a fait accompli. And if you'd had a written constitution, that might have been different. Again, another example, if you'd had a written constitution, almost certainly it would have enshrined UK membership of the EU within that constitution, and it would have enshrined, or that would have had consequential implications for how that membership could have been changed from a UK domestic political perspective. The final point to note here within the limits of time is a very simple but fundamental one. Unwritten constitutions such as the UK tend to be inherently under-constitutionalized. Constitutions can be over-constitutionalized and not leave enough to the domain or sphere of everyday politics. However, they can also be under-constitutionalized, and there's a very strong argument that the UK Constitution is under-constitutionalized and does in the sense of not providing enough constitutional guidance. And that's because of the primacy accorded to parliamentary sovereignty. I mean, the unwritten constitution in the UK has as its core the very idea of parliamentary sovereignty, meaning that there can be no procedural or substantive limits on what Parliament can do. But if that's the core of your constitutional order, then it very much circumscribes any external limits. I mean, viewed in one way, there are no external limits. And in that sense, we're radically under-constitutionalized. Parliamentary sovereignty, subject to some constraints on the rule of law, is the only game in town. Again, limits of time. So let me just go through the last couple of slides. So a fifth constitutional perspective, institutions and accountability. And I think that these are properly regarded as of constitutional importance or significance. So what was the impact of this? Well, the impact of Brexit was to exacerbate the shift from cabinet government to prime ministerial government. So there's a long debate in the UK about how much power resides in Parliament and how much power resides with the executive, and the bottom. But even within that, there's then a further debate about the relative power of the prime minister in relation to the rest of the cabinet, rest of the executive. The bottom line is that in institutional terms, both under Theresa May and under Boris Johnson, Brexit further enhanced the power of the prime minister and the Downing Street cadre of advisors, and further augmented that power even in relation to the rest of the cabinet. And that was highlighted or reinforced in normative terms both by Theresa May and Johnson, who very much sort of presented their normative vision about Brexit as a vision which had, as it were, presumptive normative weight, such that to disagree with it was somehow illegitimate, and that they were regarding themselves as the ultimate voice of the people and expressing the people's wish, and that if you question that, you are questioning not only the authority of the prime minister, but also the authority of the legitimacy of the vote by the people to lead the UK. Finally, and I could easily devote hours to this, Brexit had some pretty important implications for Parliament and the courts, or Parliament's executive and the courts. There were lots of legal cases, one way or another, about Brexit. The two most significant were Miller 1 and Miller 2, both of which have given rise to very significant amount of academic literature. Even more Miller 2 than Miller 1. My own view is that both decisions were right. And quite a lot of people agree with that. And there's a number of people who don't. So basically the issue in Miller 1 was whether the government could trigger Article 50 and begin withdrawal from the EU without statutory authorization from Parliament. And why was this an issue? How did it come about? Well, it's because in the UK, we have this thing called prerogative power. Prerogative power is a non-statutory discretionary power which resides in the executive as a matter of history. It's not open-ended, quite the contrary. There's prerogative power in different areas. So the executive would have a prerogative to make war and peace. They have a prerogative power to make treaties and unmake them. So basically, Theresa May said, all right, the people have voted. I am now going to trigger Article 50 and decide to leave the UK without actually getting a formal authorization from Parliament. And this ended up in the courts and in the Supreme Court, where the Supreme Court said, no, you can't do that. There are boundaries or limits to prerogative power, and the consequence of those boundaries or limits is that you, the executive, have to seek statutory authorization before you can trigger exit. Again, I think that was right, though that one was an 8-3 split in the Supreme Court, but I think the majority got it right. Miller 2 was more controversial, but it was a unanimous decision. Again, it involved an issue about the boundaries of prerogative power. And the way in which the issue arose on this occasion was that the prerogative power involved in this instance was a prerogative power to prorogue Parliament. And what prorogation means in the UK system is that, okay, you get Parliament elected for a period of years, but you can end a session of Parliament through prorogation. And normally, when you end a session through Parliament, through prorogation, two things happen. One is that existing legislation stops and has to be started afresh. But normally that's not a problem. And normally prorogation, when it occurs, is just 2-3 days. So you end one session, everyone has a break for 2-3 days, and then you come back and start a new session. What was controversial here was that the government had a 5 to 6 week prorogation at a crucial time when Parliament was trying to debate Brexit and debate the withdrawal agreement. So it was argued in Miller 2 that the use and exercise of the prerogative of prorogation in this instance was unlawful. And they said, and I think it was right, and I've written at length about this, they said, yes, it was 11-0, no separate opinions. Now that generated a whole series of really pretty controversial exchanges, because those who, in particular, those who thought the opposite were really very critical of the court and used often very critical and intemperate language to criticize the UK Supreme Court. So I and a number of other people, as it were, came to the defense. Key point to understand here from a broader constitutional perspective is that one of the key takeaways here is that those who don't like these decisions try to portray this as courts aggrandizing their power at the expense of the legislative institutions or the political institutions. That's quite wrong. That doesn't withstand scrutiny. The key issue here was not courts aggrandizing power to themselves. This was not courts trying to grab power or arrogate power or increase their own power. The courts were faced with a zero-sum choice. And the choice was, do they side with the executive or do they side with the legislature, basically, okay? In both instances, the real protagonists were the executive and the legislature, okay? If they had upheld, if they had decided the other way in Miller 1 and Miller 2, the body that would have lost out is Parliament, the legislature. In Miller 1, it would have meant that the legislature had no voice before exit under Article 50 was triggered. And in Miller 2, it would have meant that the time for parliamentary debate would have been radically curtailed and that thereby diminishing parliamentary power. Now, I'm very sorry I have gone on for too long. I apologize, but I'm certainly going to stop now. And I appreciate your listening, and I hope some of this has been understandable. And I will stop sharing my screen now, and I'm very happy to take any questions. Thank you.
Professor, muito obrigado pela sua brilhante exposição. Eu, há cerca de 6 meses, comecei a estudar o direito europeu e a complexidade do direito europeu e as relações do direito europeu com os direitos nacionais é realmente um tema fascinante. É um tema muito complexo e que dá pano para manga, dá muito assunto para ser debatido. Eu queria, sem delongas, passar a palavra para o nosso debatedor, o Dr. Rodrigo Brandão, para trazer suas considerações. Por favor, Rodrigo, você tem a palavra.
Good morning, everybody. Initially, I would like to thank Professors Luiz Claudio Martins and Professor Cristina Gaulia for this invitation. It's an honor to participate in this panel with my colleague from Public Attorney, Rodrigo Valadão, also. I would like especially to thank Professor Craig for his talk. I've learned a lot. I'm sure that everybody learned a lot about this, the current relations between the UK and European community. One point that was very interesting from my point of view is this uncertainty about British law, which European treaties and norms are integrated to British system and the ones that won't, because did not fit post-Brexit reality. And so this is a point that Brazilian lawyers and professors are used, because although our systems are very different, we have a presidential system, a written constitution and practice, judicial review for more than a century. We deal with this a high degree of uncertainty with our law, our legislation, sorry. not only because we have a federal system, but also because our legislative branch is very prolific, produces thousands of norms without big worry as British Parliament, with clarity and conformity with previous legislation. So we deal for a long time with this problem. So it's very interesting, our dialogue about this point. But I would like to pose two questions to you, Professor Craig. The first one is taking one step further. I know that's a very complex question, but I would like to listen to you a little bit, and I think other professors too, about how you see the future of the relationship between European community and the UK. You put the scenario with very clear lines. This negotiation of treaties are very complex, and the interpretation of the treaties are also very complex. But as you are a distinguished scholar about the relationship with British and European community, I think it would be very interesting for everybody to listen a little bit how you see the future. And the second question is taking one step back. It's about the decision in the Brexit referendum. How you see these popular decisions in an era of digital communication with increasing disinformation techniques? Because I think that Brexit was a leading case of the use of internet, fake news, and you posed very clearly how the promise of increasing British sovereignty and the power of British Parliament was a fallacy. It did not confirm, and it was actually the opposite. So how you see, especially these years, that all of this situation emerged after that decision. So how do you see this popular referendum in a digital era with populist and nationalist leaders that kind of manipulate information in this scenario? And a final question, I'm a constitutional professor here at State University of Rio, so I would like to listen a little bit, Professor Craig, about the impact of introduction of Declaration of Incompatibility by the Human Rights Act. How was this experience of judicial review in the UK, as long as you have this long tradition of the supremacy of Parliament? And thank you very much, Professor, for your wonderful speech. I've learned a lot. It was delightful for me.
Thank you very much indeed for your kind comments and your excellent and insightful questions. So in fact, we have three issues. Let me take the looking back one first, and then I'll do the looking forward one. And then I'll deal with the HRA. So looking back to the referendum, I've got pretty clear views about that, but they're probably quite predictable. But I'm being as objective as I can. And I've had a long time to reflect on this, so it is what it is. But my view is as follows. I really am very a great believer in democracy, and I'm a great believer in people's choices and voting and public participation. Excuse me. At the same time, to have a referendum on membership on a very complex issue like EU membership is problematic. It seems to me that other things being equal, referenda as a mode of deciding something is better or easier when the issue is much more specific, much more targeted, much more singular. The reality was that when a very great number of people voted in the referendum in 2016, and I do not mean this in any pejorative sense, but it's simply factually true, they had no idea really what they were voting for, and they had, in many instances, no idea of, or very little idea of what the EU did, or what benefits they might have be getting from the EU, or anything of that kind. So, for example, it was the case that many people in manufacturing industries, in heavy industrial areas, were voting against the EU. And you just think, why are you doing this? I mean, in a double sense, you're voting against your self-interest. One sense is that if we come out of the single market, your industry is going to suffer because it's going to face extra trade barriers in Europe. Secondly, many of the social labor rights that you have, or equality rights, come from the EU. You know, I mean, they were EU legislation and EU enforced rights, which gave workers' rights of a kind that they would almost certainly not have had to that degree. So I think, you know, one of the tragedies of looking back at Brexit was the people didn't fully understand, or didn't understand much at all about what they were voting for. There was also, as you rightly said, much fake news, much conscious disinformation. So, for example, one of the most visible manifestations of that is that Boris Johnson went around on what became known as the Boris bus. It was a coach, and it had on the side a slogan, 350 million pounds per week, you know, the allegation being that this was what it was costing us to be in the EU. He was told time and again that this figure was wholly inaccurate as a reflection of what it was costing us in either gross terms or net terms to be a member of the EU. Did he change it? Of course not. Of course not. There was also much fake news in terms of fears about migration. Again, I mean, and this was actually deeply shaming, I felt, I really did, deeply shaming on the British, or to be British in those circumstances. They just played on anti-migrant fears. They played on an image of EU workers coming to the UK, stealing the jobs of UK workers, and just being there to take the social welfare benefits and not to do a proper day's job. And again, there were detailed studies which were done, which showed that the net benefit of EU migrant labor in the UK between 2004 and 1999 and 2016, the net benefit, meaning the benefit that our economy gained, even given what it cost in terms of education, the net benefit to the UK from EU migrant labour was in the order of £15 billion. And ideas that EU workers were taking jobs which UK workers had or wanted, again, almost groundless. They were normally taking jobs that the UK workers didn't want to do, or at the other end of the scale, they were well-qualified doctors, lawyers, architects who were performing a great job in the UK economy. So yes, you're right, there was a lot of fake news, a lot of disinformation from the Leave camp, and the Remain camp never found a very effective way of confronting that. And just one final point on that question before I move on to your other questions. One final point on that. One of the other tragedies about the vote was, and it would have changed the vote, younger people, people below 25, were, not surprisingly, heavily in favor of the EU. So about, the polling figures showed that about 70% of under 25s were in favor of EU membership. The tragedy was only 30% of them voted. Only 30% of them voted. Why didn't they vote? Well, they're young, they were young and they thought, well, they just thought it was in the bag. They thought we would win anyway, that they thought that we wouldn't leave. And they just didn't, not enough of them got their act together to vote. So all of that points to the fact that the Brexit vote in 2016 was a long way from ideal. But of course, what happened thereafter was entirely predictable, which is that any attempt to revisit that vote was treated by Brexiteers as, anathema. You can't revisit the vote. The people have spoken and they have spoken to leave. End of story. They didn't want to revisit it because basically if you've got the answer you want, you don't want to ask the question again. So looking forward in terms of what's the relationship going to be? It's an excellent question, not one which is terribly easy to answer. Let me, let me try and give in brief, just to put 3 dimensions to in answering that question, which are related but distinct. Number one is there are ongoing problems with the Northern Ireland Protocol, and they are serious problems. And it's not impossible that the UK would trigger what's called Article 16 of the Northern Ireland Protocol and cease to apply the key provisions of the protocol. That would then have very serious ramifications more generally for relationships between trading relationships and broader relationships between the UK and the EU. So one joker in the pack is what happens with Northern Ireland. A second joker in the pack, a second, as it were, uncertainty, which will have wider implications, is what happens to the level playing field stuff. Okay, these are hard treaty obligations, and if you break them, they all have consequences, trade consequences and broader consequences. Now, I don't know what's going to happen, but just to give an example, Lord Frost, who negotiated who was the key UK negotiator around Brexit. And is the key negotiator on the Northern Ireland Protocol with the EU, the present problems with the Northern Ireland Protocol. He's the UK lead person on that. He gave a speech literally yesterday or the day before to a conference think tank, basically saying the UK needs to move consciously away from the EU social model, needs to be a deregulated, non-EU social model type of economy with lower taxes, less regulation, etc. Now, if you pursue that seriously, then pretty quickly that's going to run into problems with the level playing field provisions, which are in the TCA. You'll end up, at least from the EU's perspective, very arguably breaking or violating the level playing field provisions. That will then have consequences for the future trade relationship with the EU. A third variable which will affect UK-EU relations is about services, and more particularly financial services. The UK is still pretty worried that about non-access to the financial markets and banking markets in the EU. And the EU is keen to turn the screw or preserve pressure on the UK in that respect. Amsterdam, Paris, and Frankfurt have all pushed for business to try and take business from the City of London. They've succeeded to some extent, but everyone's still sort of holding their breath a bit to see what the final shape of a deal on financial services between the UK and the EU for the future might be. That is not sorted in any detail. And depending upon the content of that, depending on what the deal is, you might then see a further migration of business away from the City of London and to the continent, which would have pretty significant implications. Fourthly, and then I'm going to stop, fourthly and finally, there's simply no doubt, forget the more complex things, there's simply no doubt that ordinary trade in goods is a lot more complicated in a post-Brexit world. There are, reports from all branches of industry saying that, if you're just making washing machines in Birmingham and you're trying to ship them into the EU, it's just a lot more complex and a lot more costly, because even assuming you don't have to pay tariffs, there's a whole series of customs declarations and customs forms that you have to fill in, which you never had to fill in before. And unless you have the right forms, your goods don't move. And that all entails extra costs, which are quite significant. So that's some kind of picture on what might happen in terms of future relations. And then, so your third question was about declaration of incompatibility. This is not, yeah, was that right?
Exactly. Right.
Okay, and you mean under the HRA?
Yeah, the Human Rights Act.
Okay.
How do you evaluate the experience of this 20 years of declaration?
Okay. So this is a different sort of question. In other words, this is not directly connected with the EU. So just, I'm sure most of you would understand, but basically we have a soft form of constitutional review. Because we have parliamentary sovereignty in the UK, we have a Human Rights Act, but it's not open to a UK court to invalidate a UK statute, to strike it down or annul it because of incompatibility with the protected rights under the HRA. So the schema under the Human Rights Act of 1998 is the courts cannot annul or invalidate UK legislation. However, they can issue a declaration of incompatibility, which says that a statute, for example, is inconsistent with Article 10 of the European Convention on Human Rights, which has been brought into the UK by the Human Rights Act. What then happens under the HRA is that does not formally do anything. What it does is kicks the matter back to Parliament, and then it's open. The last word is with Parliament, and Parliament can decide whether to accept the court's judgment. And if it decides to change the legislation, there's a fast-track way of changing the legislation. There's in effect a Henry VIII clause, which allows secondary legislation to be enacted, which would remove the problem created by the primary legislation. So I think there are 2 points to be made about, 2 general points to be made about the way in which this has worked for the last 20 years. Number one is that in pretty much every case where a declaration of incompatibility has been made by the courts, Parliament has acquiesced, has passed legislation to correct the problem, has amended the legislation. Some people argue that Parliament is being too quiescent, that Parliament should push back on the courts. But that misses the reality in the following sense. In most of these instances where the court finds an incompatibility, this is not a case where Parliament has made a conscious choice in the legislation and then the court has come along and said, oh, that conscious choice is contrary to the HRA. Normally what's happening, I'm not saying that can't happen, but that's just not the paradigm. The paradigm is more a situation in which you've got a complex piece of legislation, it's got 100 sections and various annexes, and then someone, when the statute becomes live and goes into operation, realizes that in section 38(1)(a), hey, there's a problem about the presumption of innocence, or there's a problem about freedom of speech, or there's an equality issue, and no one quite necessarily recognized that the issue was going to be a problem, and then until you put it out there for real. And the consequence of that is that when the court reveal the problem, then the answer is that Parliament's usually willing to say, all right, we didn't quite realize the problem, we'll sort the problem. So that's the first. So the first comment is, in most instances, Parliament simply signed up to the deal and accepted what the court said. The other point to bear in mind because it's very important, is this. Parliament only gets to have this reserved power under the UK system if the court decides that the legislation is incompatible with a convention right. However, the alternative way in which the court can go is that the court might read the legislation very creatively or quite creatively and with a strong presumption in favor of human rights. It will read the legislation and interpret the legislation to be consistent with convention rights. Yeah. Now, in those circumstances, you've now got the legislation having been reinterpreted to mean to be consistent with convention rights, but Parliament has no window of opportunity to say whether it likes this reinterpretation. Yes, of course, it could exercise its ultimate parliamentary sovereignty. It could exercise its ultimate parliamentary sovereignty. If it doesn't like the judicial interpretation, it could pass legislation amending or repealing or overruling what the court's done. But that doesn't detract from the fact that the schema of the HRA only gives Parliament voice if the court has said that the legislation is incompatible. Paradoxically, the Parliament doesn't have a voice if the courts read the legislation in a manner to make it rights consistent, because then it never goes back to Parliament in that sense at all. And it does that a lot.
Thank you very much, Professor Craig. And sorry for posing a question that is not connected with your lecture, but it's been
That's fine.
Quite discussed in Brazil, this change in British system. Yeah, and I would like finally to congratulate Professor Luis Claudio for this wonderful event. We are all delighted for it.
Oh, thank you, Rodrigo. Thank you, Professor. Eu vou passar a palavra aqui para o Luis Cláudio para ver se ele tem alguma consideração.
Thank you, Rodrigo. Well, first of all, thank you, Professor, for enlightening us with this topic. It's so interesting. And I'd like to say, as I said before, say again, that you are so kind during my supervision and so available during my supervision. And now you are so kind as well for accepting this invitation for this lecture. So thank you, Professor, for this. I know that you are out of time, but if you have some minutes for just one question. You were talking about the Miller 2 case from 2019, if I'm not wrong. Wasn't the end of your presentation. I was writing down a lot of things that you are sharing with us and a lot of information. And I wrote down about the Miller 2, and I gave a lecture in EMERJ in 2019 about this constitutional case, etc. And I was talking about Miller 2, and I was wondering if Miller 2, because was interference of the UK Supreme Court in the Prime Minister decision. That's a fact. And the UK Supreme Court is quite recent. Now you know about it. And I was wondering if the Miller 2 could not be the next Marbury case in the UK. So, because what's the point? The perspective of the posture of the court in the near future. Will it be more proactive or more self-restraint in the future? And as Rodrigo said before, in regard of the Human Rights Act, you could see a court in the near future more proactive or more self-restraint. What do you think, Professor, in regard of it?
Thank you, Luis, for the really interesting question. So, very briefly, I don't see the UK Supreme Court suddenly becoming very much more proactive, very much more interventionist, activist, whatever. It's quite clear that the judgment, I think, in Miller 2, I think is correct, and I think it's powerful and compelling. And it was right. At the same time, that judgment did give rise to a considerable legal backlash in some quarters and also some political backlash. And I also think that the present personnel on the Supreme Court, including the President of the Supreme Court and a number of the other key players, are rightly mindful of their role within the UK constitutional order and are rightly mindful of the limits of what they should be doing. And linking your question back to the previous question about the HRA, one way to exemplify the point that I'm making is that way before, ever since we've had the HRA, in a whole series of leading House of Lords and Supreme Court decisions, the UK Supreme Court has gone out of its way to make very clear that even though it's engaged in rights-based adjudication under the HRA, it believes that respect or deference should be given to the legislature and the executive, even in rights-based cases, on what academics have classified as either epistemic grounds, institutional grounds, or constitutional grounds. Okay? So there's case after case, the courts make clear that even though they're adjudicating under the HRA, that if you've got instances, I'll give you one example just in a moment, but if you've got instances where the legislature's made a considered choice and a thoughtful choice, then in the circumstances that should be fully taken into account by the court, and it should affect the type of scrutiny which the court undertakes. Let me just give you one example very briefly then. There's a case, this was just before the House of Lords became the Supreme Court, a case called Animal Defenders. So in this case, the issue, the relevant issue was whether it was about political advertising on TV during an election time. Okay. Now, in effect, the Communications Act of 2003 contained a complete ban on such advertising, and it was argued that this complete ban was contrary to Article 10 of the European Convention on Human Rights. And indeed, there was some case law in the Strasbourg court which lent weight to that view. But Lord Bingham, giving the judgment for a unanimous House of Lords, did not accept that it was in breach of Article 10. Basically, what he did is that he accepted, yes, of course, that there was a prima facie limit on freedom of speech. And then he looked at justifications under Article 10.2. And he considered the reasoning process that informed the legislature's decision to have a total ban. And it was clear that that was a thoughtful process which reached the conclusion you should have a total ban for two reasons. One, political advertising on TV during election time was a very powerful form of stimulus in an election, and money mattered in terms of how much TV time you could buy, and therefore it could disproportionately favor the rich or the richer parties at the expense of the poorer parties. Secondly, and really interestingly, when Parliament enacted that legislation, it thought quite hard about total ban versus non-total ban. And it was clear from the legislative history that the Parliament played around with various possibilities of not having a total ban, okay? So you could have a partial ban whereby, okay, one version of a partial ban would be any one person or any one company is only capable of spending 50,000 on political advertising or something of that kind. Okay. And what became apparent in Parliament was it was very difficult to set up a partial ban that could not be easily circumvented. Yeah, that the partial bans wouldn't be worth the paper that they were written on, that they would be easily circumvented, and in effect, you wouldn't be having any controls at all. So Bingham gives respect to that legislative choice and upholds the legislation in the circumstances. So what I'm saying really, Luis, is that our courts, ever since we've had an HRA, even though they're rights-based adjudicators, they're rights-based adjudicators which recognize the limits of the powers that they should be exercising in relation to the other branches of government. So I don't see any, huge surge of activism coming from the courts.
Thank you, Professor. Thanks. It's very nice for this point. It's quite interesting because I saw Mirror 2 as a new perspective of the court and maybe changing the near future, the posture of the UK Supreme Court. I understood your thought. You're saying that it's more in regard of the limits of the bench, but I was thinking in the future, a changing in the posture of the court. Thank you, Professor. Rodrigo.
Ok, Luiz, muito obrigado. Gente, eu acho que a gente já está aqui no adiantado da hora, né? Tema muito interessante, sem dúvida. Eu mesmo tenho, enfim, diversas perguntas aqui para o professor, mas pelo adiantado da hora, eu acho que já tá de bom tamanho. Queria agradecer aqui, em primeiro lugar, ao Luiz, né, Luiz Claudio, por organizar esse evento, coordenação científica, realmente um tema, cara, muito interessante, que dá pano para manga. Agradecer aqui o Rodrigo Brandão, meu xará, perguntas super pertinentes, super interessantes também. Vou pedir, agradecer, claro, ao ouvinte, a quem está nos assistindo agora e quem vai assistir depois pelo site da EMERJ, e vou pedir licença aqui para dirigir as últimas palavras ao professor em inglês. Tá? Professor, thank you very much. On behalf of EMERJ, I would like to thank you very much and congratulate you for your lecture. I myself, I had a lot of questions that I would like to address, but unfortunately, we have no time for that. And that's it. If you have any final words, please The space is yours.
I would merely like to say thank you. It's been a great pleasure. Thank you for inviting me. It's been a great pleasure to meet up via Zoom. And thank you for the audience for listening. I hope it was understandable. And when circumstances permit, then it may be that we may be able to do something in person, but that may be a little way off yet. But it's a great pleasure to take part, and I very much enjoyed the session. And thank you for the hospitality and the excellent questions that were forthcoming. Thank you.
Bom, e assim, com as palavras finais do professor, eu agradeço mais uma vez a audiência de todos, a participação do Rodrigo e do Luiz. Agradeço mais uma vez o professor Paul e declaro encerrados o evento. Muito obrigado e uma boa tarde a todos.
Thank you, Professor. Rodrigo.
Thank you, Professor.
Um abraço.
Thank you, guys.
Thank you, Professor. Bye-bye.